Privacy issues continue to plague the U.S. as technology advances and new devices are introduced. Companies, on one hand, often utilize user data to develop new products and systems, but consumers, on the other hand, believe that their privacy should be protected against data collection. And this debate has been highlighted through multiple events over the past couple of years, but most recently, it was sparked when the Federal Trade Commission brought action against MySpace for violating its users' privacy. Although the company was able to reach a settlement with the FTC, many are speculating that this is just the beginning of the Commission's greater effort to combat privacy concerns. And Robert Ellis Smith, the publisher of the Privacy Journal, is joining us now by way of phone to offer his insight into these latest developments. Thanks for being with us today, Robert.
Happy to join you.
Great. Well, in terms of the MySpace case, first of all, what specifically did the company do to result in the FTC's intervention?
The Federal Trade Commission law says that once you advertise a product or a service or represent it as such and you don't fulfill your promise, that violates the fair trade law, not a privacy law as such. It is a failure to live up to some promise you made. The most common cases that the FTC has taken has been advertising, but they also take cases involving online providers and social media where they promise to do certain things, namely keep information private or to give people the right to see information about themselves and to correct it, and then they fail to live up to that promise, and that's what happened in this case.
So now, what is MySpace required to do as far as the terms of the settlement go?
The most important thing is to open up their books to audits by the Federal Trade Commission for the next 20 years. Google had to agree to the very same thing. It has to certify that it will comply with the traditional U.S. principles of fair information practices. Those are the same principles that allow American companies to continue to do business over in Europe, where there are very strict national laws about consumer privacy.
What message does this send to other websites, especially those with social elements such as Facebook and Google?
Well, I think that, first of all, it shows a maturity of the Federal Trade Commission because in the fall of 2011, it went after the two largest online companies in the world, namely Facebook and Google, and reached settlements with both of them. Now they have successfully reached a settlement with MySpace, which is a significant player in the social media field. That's the first thing. The second thing is I think all three settlements show a recognition of age-old privacy principles, been around now for about 20, 25 years. Among other things, that you have to provide individuals who do business with you some means to see the information you have on them and to correct it if necessary. But also, significantly in the MySpace case, to not take information for one purpose from your customers and use it for a second purpose. That was another violation that the Federal Trade Commission charged with MySpace. And thirdly, I think it shows the strength of this fair trade law, which has been around before email, before internet, before social media, that it still has principles in it that you can hold companies accountable if they don't keep their promises to consumers.
Do you think that other internet sites will take this seriously in light of the fact that MySpace is somewhat irrelevant when compared to Facebook and Google now?
Well, it is as a business entity. I suppose that's true, but the principles of the settlement, I think, are very important. And the lesson here is you may not have to have a privacy policy. You risk losing customers if you don't. But once you decide you're going to have one, you better abide by the one that you developed. They are not just window dressing. That's the important message of all of this. So maybe the MySpace settlement has a little less influence. And in fact, one of the things they ordered MySpace to do is to continue to abide by the law. Well, we're all obligated to do that anyway. So some may find it as rather weak. But I think the fact that two social media sites, major ones, especially ones involving children, young people, have caught the eye of the Federal Trade Commission is significant.
Well, both the White House and the FTC's privacy reports released earlier this year pushed for the industry to enable measures such as do not track. How are these efforts coming, in your opinion?
Well, the Federal Trade Commission, as it normally does, is kind of holding out for voluntary compliance by companies. And voluntary compliance, I think, has been slow in coming. And companies have been through this scenario before. They know that if they dally too long, the Federal Trade Commission will step in. In fact, the FTC has recommended to Congress that it enact do not track legislation. That really is a Internet World Wide Web counterpart to the do not mail list and the do not call list that the Federal Trade Commission already has actively. So it would be a requirement that you'd have to give customers a chance, an easy chance, to opt out of being tracked when they use a website. I wouldn't expect any passage of this in this election year, but perhaps a year from now, I think you might well see Congress move on this.
Interesting. Well, at this point, the FTC can only intervene if a company violates its terms of service agreements, as you mentioned. But there is talk that the White House wants to expand the Commission's power beyond this. So could you see this happening, first of all, and really what kind of enforcement could this give to the FTC?
The White House has kind of pushed the Federal Trade Commission to be the lead agency on privacy, and that's fairly new. Still, the FTC has limited jurisdiction. It has jurisdiction only over commercial entities and only over those companies that violate what they promise to a consumer. It has no jurisdiction over electronic surveillance, over medical records, and a lot of other aspects of our lives. And a lot of Europeans have a hard time understanding that, but that is the truth. And the White House is trying to move the Federal Trade Commission into a position where it'll be kind of a focal point for privacy, even if it wanders a little bit, tiny bit, beyond its jurisdiction. One person who's been pushing this is a commissioner named Julie Brill, who's been there now for about 2 years. She formerly was the Assistant Attorney General in Vermont, where she came up with a lot of innovative cases involving privacy online and offline, too. And she's really sparked, I think, the Federal Trade Commission in her kind of subtle, persistent way to move forward on this. And it has kind of a progressive makeup right now. With the Obama administration, the new chair of the FTC is more progressive than had been the prior chair. During earlier administrations, the chair often took a laissez-faire attitude, pushed for voluntary compliance, but never backed it up with a really meaningful threat that there might be some statutes passed, too.
All right. Well, some people are also speculating that really all websites are going to become prone to FTC scrutiny. Do you see this happening, and how could the FTC keep up with all of these websites?
Well, it's terribly difficult. They're trying to build up their staff to do exactly that. They depend on a lot of people like us to tell them when there has been a violation. A lot of us think that when we complain to government agencies, nothing happens, but those letters do mount up. Those complaints do mount up, and that's one way that the FTC is led to its compliance cases, by the nature and the frequency of complaints that it gets. It's not a large step for the Federal Trade Commission to have jurisdiction over all websites, although we should remember these would still be commercial websites. It would not have jurisdiction over governmental or nonprofit websites. The key here, the crux here, is whether there is a misrepresentation of some promise to a commercial customer.
Well, do you have any suggestions for companies looking to avoid the FTC in court?
Yeah, they're pretty basic, I think. The principles are called fair information practices. We list them on our website, by the way, which is privacyjournal.net. They've been around now for about 30 years. There's been common agreement among governmental agencies on both sides of the Atlantic and major business associations in the United States that these are fair principles, and the FTC continues to go back to these principles when they go after a company. And so that's the first thing to do, is to make sure your company is complying with those principles. Secondly, you got to have somebody responsible on your staff who knows what the laws are. They're a little tricky now, and no one law applies. That your company might be affected by 3 or 4 privacy laws, so it's important you know exactly what your requirements are. Quite often companies look at the laws that affect them and find out they're not as onerous as they had once feared. And you should always be transparent. You should tell people what you're doing. That's been Facebook's problem, I think. They have not told their users, their members, their friends exactly what they're doing. And the more transparency there is, the more openness about one's policies, the fewer complaints you're going to attract. Everybody should have a privacy officer. That usually is a component of these settlements, and any company now should have a privacy officer. It doesn't have to be full-time necessarily. Mm-hmm. Could be in the legal department, could be in human resources, it could be in the president's office, it could be in the IT department. It fits in any one of those, but it's very, very important to have somebody responsible for privacy compliance, responsible for taking complaints, and responsible for internal audits of the company. There's a concept that is catching on in Canada more than here called privacy by design, and all American companies ought to be involved with that. The whole idea there is that if you go back after you've designed an information system or a policy or a practice, and then you try to patch on privacy later, you're going to have troubles. If privacy is part of the equation when you build a new system or start a new practice, it's going to be a lot cheaper, and compliance is going to be a lot easier.
Right. Well, most companies opposed to privacy intervention and regulation are afraid that innovation would be threatened as a result. Do you agree with these claims?
No, I really don't, in that there's a concept also called privacy-enhancing technologies. There's no rule that says technology has to threaten privacy. Mm-hmm. Many of them enhance privacy, and we should rediscover that idea that in making your website more privacy-friendly, you're going to come up with some technologies and some practices and policies that make sense for the company throughout. So far, I don't think that any of the privacy obligations that have been imposed by the government have slowed down technological development at all. Certainly they have not slowed down profit-making, because these companies are doing very, very well. I noticed in the 70s, and I've been doing this for several years, but in the 70s when the Federal Trade Commission regulated credit bureaus, they still do, by the way, but when they started to and got more vigorous, those were amazing years of profit-making and growth for the credit bureaus that were first subject to Federal Trade Commission scrutiny. They had these same kind of settlements that the social media companies have now, and they said it would retard progress and cut into their bottom line, and in fact, it's had the opposite effect. They've thrived during this regulatory period.
All right, well, Robert, thank you so much for sharing your perspective. We really appreciate it.
Okay, enjoyed talking to you. Thank you.
You too. With this Web Per News Report, I'm Abby Johnson.